So welcome everyone to this data protection update for independent schools. My name is Andrew Gallie. I'm joined by my colleague Claire Hall, and together we'll be talking you through some of the issues that have been keeping us busy over the past couple of months. Next slide, please, Emma. So Claire is going to start off by talking about subject access requests, and I'm then going to look at police requests, and also how you should approach photographs and videos for marketing and publicity purposes. We've kept the agenda here quite short because we really want to sort of encourage people to ask questions. So please feel free to ask anything as long as it's data protection related, whether it relates to the topics we're covering today, or you have a more general question on data protection compliance. So I'm now going to hand over to Claire, who's going to talk about subject access requests.
Thanks, Andrew. So Andrew mentioned that the purpose of the webinar today was to talk about things that have been keeping us busy over the last few months, and subject access requests was the topic that instantly sprang to mind when we started thinking about what to talk about today. So Andrew and I have been advising on data protection law for independent schools for more years than I think we'd care to admit, way before GDPR came in. But over the last few months, we have seen independent schools receive more subject access requests than at any time either of us can remember. I'm even aware of some schools who are dealing with multiple requests at once at the moment. So it really is kind of the hot topic at the moment. The first slide we've got here about SARs is regarding preparing to receive one. If you haven't dealt with one over the last few months, I think it's a relatively safe bet to say that the next academic year is likely to see your school receiving at least one. So I think the first thing to think about is how to make hay while the sun's shining over the summer, and think about how you will deal with receiving a SAR if that does happen next year. So the first thing to think about really is, how are you storing data? Are you storing it in a way that will make it easy for you to search for personal data should you receive one? So emails are always a difficult one when it comes to subject access requests. So let's think about, first of all, email filing. So, do you have protocols and rules around how staff members file emails? Or do you simply allow staff members just to keep everything in their inbox? So if it is the latter, I would suggest thinking about how maybe you could change that so that the really important information is stored differently from, the routine emails, that kind of thing. The more for the relevant personal data if you do receive a subject access request. The next thing to mention is staff training. So in terms of subject access requests, they can be made to any employee at your school, and they don't have to be made in writing either. So it's really important that staff members know how to recognize a subject access request. They don't have to use data protection law or the word subject access request to make one. And they can also be made, as I said, orally as well as in writing. So make sure staff members know how to recognize one. Staff members should not be encouraged to respond themselves. They should pass it immediately to the data protection lead at your school, because they can be quite complex to deal with, and there are certain challenges around timescales and that kind of thing. So they very much should be led on by the data protection lead at the school. The other point to mention regarding staff training is just a kind of a word of caution really to staff members, that they should be professional regarding any kind of recorded comments that they make about individuals, because it's not always possible to find an exemption to withhold data under a subject access request. Staff members, I think, really should by now be aware of that. It's something that we have been talking about for a few years now in the sector. So hopefully that's the case. But staff should really understand the basics of a subject access request, i.e. that it is a request for the individual's personal data, and that there are exemptions to disclosure, from disclosure even, but they're not that wide-ranging, and they can only be applied in limited circumstances. I put retention as the next point because if you think about someone asking you for all the personal data you hold on them, that can be a vast amount of data. And we'll talk in a moment about clarifying requests and that kind of thing. But if you have a good retention system in place, by which I mean a retention schedule that you abide by, you are minimizing the data that you hold to only that you need to hold. So that can sometimes make it easier, because the less information you hold, the less information you have to search through. Obviously, any retention advice we would ever give is always subject to the independent inquiry into child sexual abuse caveat, that you shouldn't be deleting information relevant to the inquiry, but still think about how you are going through your own retention schedule and how you are putting that into practice. School holidays is the next point. There is no exemption for school holidays. The clock doesn't stop ticking when we break up for summer holidays, Easter, Christmas, for example. You can have an extension for complicated requests of up to 2 months, but school holidays aren't a factor in that. So unfortunately, the clock does keep ticking. And that does mean that you can receive requests during the school holidays as well. So have a think about what measures you have in place to make sure things are picked up, whether they're sent by post, by email. So if staff members aren't going to be checking their emails, for example, they should have an out of office on. The last bullet point is a slightly ambiguous governors, and that really is just a reminder that your governors can also receive subject access requests. Requests can be made to a governor as well as a staff member. The second point on governors is that I still see governors using non-school email accounts, addresses, for doing their governor work, so for processing personal data on behalf of the school. So governors really should have a school email account. If you receive a SAR and you know the governor has been processing personal data that's relevant to that SAR on their personal email account or on their work email account, for example, you do have to take measures to make sure that those accounts are searched. You only have to do that if you have a reasonable belief that the email accounts will hold relevant personal data to the subject access request. It just makes things easier, essentially, if governors are all using school email accounts for subject access request purposes. There are also information security, considerations here as well that I'm not going to get into, but for the point of this slide, just preparing to receive a SAR, please just make sure your governors are using school email accounts. Next slide, please, Emma. Okay, so this kind of is the kind of initial considerations around subject access requests. And I should say at this point, I'm not planning on going through how to deal with a subject access request stage by stage, because I've only got kind of 20-25 minutes to talk to you, and it would take hours to go through everything you need to know about subject access requests. So these are very much the high level key points that it's good for you to know in anticipation of receiving one, and also the lessons learned, I think, that we at BWV have come across over the last few months when advising schools on these types of things. So wanted to bust a few myths as well. And the first myth I think I wanted to bust on this slide is that you always have to ask for ID. You don't always have to ask for ID. You should only ask for ID if you need to. Now, need is a relatively low threshold because we're talking about information security here. So if you have any doubts at all that the request has come from the person who it's reporting to come from, yes, by all means, you should absolutely be taking measures to satisfy yourself the request is genuine. But it doesn't mean that you should be routinely and as standard practice asking everybody who makes a subject access request for a copy of their passport, for example. You should be treating a current staff member making a subject access request quite differently to someone saying that they were a pupil at the school 10 years ago who out of the blue has now come back and is making one. So it's about what's reasonable in the circumstances, and don't ask for more personal data than you need to satisfy yourself that the request is genuine. We often in a school context see subject access requests being made by third parties. Often it's a solicitor, for example, or maybe a staff member or a parent making it on their behalf. That's absolutely fine, but the third party needs to show you that they have the authorization of the data subject, of the individual who they're purporting to make the SAR on behalf of. So often it is the case that you do have to go back, for example, to a solicitor and say, look, thank you for this, but please can you satisfy us, provide us with evidence that your client has authorized you to do this on their behalf. So absolutely no problem pushing back. Just because they are a solicitor doesn't give them any more of a right to make a SAR on someone else's behalf. Also put that third parties includes parents. So as I'm sure many of you will know, once children reach a certain level of maturity, as a general starting point, we say around the age of 12, once a child gets to the point where they can understand what a subject access request is, the right is there. Well, the right is always theirs, but once they can understand what it is, it's the child's right really to exercise rather than their parents. So if a parent does make a request on behalf of their child, you do need to think about whether you need to seek authorization from that child. As I said, the age of 12 is a good starting point there. And then the third point on this slide relates to where you receive a very large or a broad subject access request. So someone saying, I want all of the personal data that you hold about me, and they've been an employee for the last 10 years, or they've been a pupil for the last 5 years, that kind of thing. So when someone makes a very broad request and you hold a large amount of personal data about them, you are entitled to go back and ask them to clarify what they are seeking. You don't have to do that. It's not a legal requirement. You can, as an alternative, do reasonable searches for their personal data. I'm quite a fan, though, of going back to ask them to clarify the request, because it's a way of managing their expectations that if they don't clarify their request and they still insist on asking for a large amount of data, your obligation is just to do reasonable searches. And that might mean that they don't necessarily get what they're looking for. So it is often a case of asking them to help you to find actually what they're looking for. Because when SARs are made, we generally know that they're made for a particular reason, even though they are technically purpose blind. So it's normally the case the person is looking for information about a particular incident, for example. In terms of how these things affect the timescale, I mentioned the clock is ticking a moment ago. The clock starts ticking when you receive ID, if it's reasonable to ask for ID. If you go back for clarification, it's slightly more complicated. So if you go back to ask for clarification, the clock pauses whilst you are waiting for their response. So if they take 2 days to come back to you after you've asked them to clarify their request, you add on 2 days to the 1 month time period. Next slide, please, Emma. Okay, so deciding what to disclose. As I said a moment ago, I am not going to go through in minutiae detail everything you should consider when deciding what to disclose. So the starting point is, remember that the person is entitled to a copy of their personal data. So think about what the definition of personal data is when you are doing your searches. So personal data, as a reminder, is information which relates to the data subject from which they are identified, or they're identifiable. So the identifiable limb of that definition means that they don't have to be identified from the face of the information. If you could piece together information and work out who it's about, then it's still personal data. So you can't get around data protection law, I suppose is the headline there, by using a nickname or by using someone's initials. If you can work out who it's about, it's still their personal data. But the relates to limb here is really important when we're thinking about what searches to do. So just because somebody is copied into an email doesn't automatically mean that that's their personal data. So just bear in mind the definition of personal data when doing your searches. Can't really give you specific advice on how to do your searches because it will vary from subject access request to subject access request. Also keep in mind what is being requested. So often when people do come back to clarify their requests, it is quite helpful, and you can then just make quite targeted searches for what they are saying that they want. And it might be the case that you have one document that contains information that they're requesting versus information they're not requesting. And strictly speaking, you only need to disclose the information in that particular document that they are requesting. Obviously, you can be more transparent if you want to be, but just to bear in mind, they are only entitled to what they are requesting. I know that sounds obvious, but I think it's a good tip because sometimes when you do a search for personal data, it can come back with thousands and thousands of entries. Next slide, please, Emma. Okay, exemptions. So as I mentioned a moment ago, and as I hope most of you watching this will know, so the entitlement is to a copy of the personal data, but that is subject to a number of exemptions. And there are more exemptions than I have time to mention here. There are lots of exemptions. But there are certain top tips that will apply no matter which exemption you're relying on. Do not apply exemptions in a blanket fashion. Just because you know an exemption might apply to information held in an HR file, for example, doesn't mean you withhold the entire HR file. I'm afraid you do need to go through the documents that you are preparing for disclosure line by line. And sometimes an exemption will apply to one paragraph or even one sentence that won't apply to the rest of the document or the information in that document. Bear in mind as well that people are entitled to the personal data that you hold about them, not to a copy of the document that contains that personal data. So Rather than making redactions, you are permitted to extract the disclosable personal data and put it in a new document. That's really useful when it comes to things like large spreadsheets, where you might have, 100 rows of information about various different staff members or various different pupils. Rather than redacting that information, you can extract it. Always keep a record of which exemption you are relying on to withhold personal data. This is part of the accountability requirement under the UK GDPR, which is the requirement to demonstrate your compliance. But it also is good practice, because if somebody complains to the Information Commissioner's Office, which many people do because it's free to do so, and the ICO asks you to explain what approach you took, that kind of thing, you need to have records that you can use to go back to the ICO or go back to the individual even and explain the approach you took. You do not have to tell people which exemption you've relied on, but it is good practice to do so. So, for example, if being transparent with the person about the fact that you've relied on the serious harm exemption or the child abuse data exemption would undermine the fact that that exemption is being relied on, you don't have to be transparent about it, but it is good practice to be as transparent as you can be. And often people will be able to work out you've relied on the exemption to withhold information about other people, for example, where it's mixed with their information, just from they'll just notice that from the redactions you've made. So do be transparent, but you don't have to be so transparent that you're telling them absolutely everything that you've withheld or absolutely every exemption that you've relied on. Next slide, please, Emma. Okay, this is the final slide on this, and this in some ways is the most important. So this is to do with information security. So those of you that have heard us speak before will know that information security really is kind of one of, if not the high risk area of data protection and compliance. So there's two key points here when it comes to information security. We've already touched on one of them around ID, so making sure that the request is not fraudulent, and fraudulent requests do unfortunately happen from time to time. So once you've got past that hurdle of satisfying yourself that the request is genuine, then it's these 2 points on the slide to think about. If you are making redactions, which often you will be, so even if you're extracting from some documents, you'll probably find it easier to redact others. Please make sure those redactions are effective. So the number of times I've seen kind of someone use black marker pen and then you hold it up to the light and you can see through the redactions, it's just, that's an information security issue. So please make sure your redactions are effective. If you are doing them electronically as well, get your IT team to stress test it, get a second pair of eyes on it, get someone to try and break your redactions. You must have measures in place to make sure the redactions are done effectively. The second point is, how are you going to send the disclosure to the person securely? So we would strongly recommend not putting it in the normal post, for example, because it might get lost. And subject access request disclosures can contain some very sensitive information, and that would be a data breach if it got lost on the way to the requester. So think about how you're going to disclose it to them securely. Again, this is probably one for your IT team around what technical measures can you put in place around encryption. How can you make sure that the password to break the encryption is only provided to the individual themselves and couldn't be accessed by anybody else? So think about what protections you will put in place, because it's too awful to think about spending hours and hours and hours doing the perfect subject access request disclosure only to fall at the last hurdle and having a data breach on your hands. So do think about these information security points. Should also say as well that in terms of subject access requests, one of the high risks is revealing too much information about other people. So if you ever have any doubts and you want an exemption to be able to rely on to withhold something, pick up the phone to me and Andrew, and we can talk you through the different exemptions that might be available. And then I haven't put this on the slide, but just to give you a heads up, the government will be reforming data protection law over the next year. We anticipate the data reform bill probably early in the autumn. The government have made it clear that they will be reforming the subject access request regime because they know how onerous it is to, for smaller organisations in particular, to deal with multiple large SARs at once, for example. So keep your eyes peeled for information from us on that. The best way to keep up to date with data protection reforms is to sign up to the data protection module of the compliance toolkit. If you want any more information about that, let me know. But the headline on SARs is that the government is going to be making it easier to refuse to respond to vexatious and excessive subject access requests. So there is some good news on the horizon, hopefully for the next academic year. And now I'm going to pass over to Andrew, who I think is talking to you about police requests.
Thanks very much, Claire. Thank you for that. And really, just before I start talking about police requests, just really to emphasize what Claire said around if in doubt, adopt a cautious approach. Nobody has ever been fined for not disclosing something in response to some access request, but a GP practice was fined a few years ago for disclosing too much. And we often sort of suggest you should almost work backwards. So if you think it's in a pupil's best interest for something to be withheld, for example, if a parent makes a request, we can usually find an exemption that sort of that would allow the yourselves to lawfully withhold the information. Okay, so I now want to talk about police requests. And before I do so, with apologies, I've got a bit of a cold, so if I sound a bit sort of squeaky, then apologies for that. So we're finding that we're getting lots of schools wanting help dealing with requests for information from the police. So I thought we would cover this off as part of this session. And a request from the police can take all sorts of forms. It could be something as simple as the police wanting a copy of CCTV following a break-in over the weekend, through to the police investigating a serious historic sexual assault and wanting information about staff and pupils and so on. So starting point, which is often forgotten, is that there's actually no legal obligation to provide information in response to police request unless and until the police produce the appropriate court order. And in my experience, they very rarely do. Notwithstanding that, most schools wish to help, and there are sort of gateways in the data protection law that allow you to lawfully share information with the police in most cases. In essence, you need to be satisfied that the police's request is proportionate. So what I would avoid in particular are what's sometimes referred to as fishing expeditions, where the police might, for example, request, all records relating to a particular pupil or a particular member of staff. And so in those sorts of cases, it's just important to sort of sense check with the police what they want and why it's relevant. The usual data protection considerations apply to police requests as they do to any other data protection issue. So before sharing information with the police, you need to identify a lawful basis. That will usually be legitimate interests. So you should do a legitimate interest assessment. But if, for example, you're making a disclosure in relation to a matter where there's a safeguarding angle, your lawful basis might be public task if you're sort of making the disclosure for in line with your safeguarding functions as a school. If what's been disclosed counts as special category data, such as health information or information about criminal offences, then you also need to identify a processing condition from the list in Article 9 of the GDPR and Schedule 1 of the Data Protection Act. There's a condition that relates to disclosures for preventing and detecting unlawful acts, so which can be found in paragraph 10 of Schedule 1. So I would refer you to that. Finally, on this slide, the police should have a form that they use to make these types of requests. So I would ask the police to put their request on their form, because that will just sort of help focus them on the sorts of points that that they should be covering off. So don't just rely on an email that says, please can we have everything about pupil X or about staff member X. So what I've set out on the slide here has really been the position for the past 15 years, and none of this is especially new. So why are we talking about this now? Well, the answer is there's been two quite significant recent developments. First is that we are finding schools are getting more requests, and the police are being much more forceful in terms of sort of trying to get the school to share information in a disproportionate way. And they're really trying to sort of twist the school's arm to make a disclosure. And clearly that raises data protection issues, but I mean, in some respects, I've got some sympathy for the police, because loads of prosecutions are falling over at the last moment because something sort of comes out of the woodwork. So it's a really tricky difficult situation for all involved. The second thing is the ICO has just produced an opinion on how the police go about collecting and processing information in relation to criminal investigations. Can we have the next slide, please? So the ICO's opinion is called Who's Under Investigation, and in essence, it's highly critical of how the police collect personal data. They make a number of points. For example, in the ICO's view, the police collect too much and they're not being sufficiently transparent with individuals when their data is collected. I would suggest that anyone at your school who's got responsibility for police requests gives it a read. It's a really interesting piece, and there's a section that deals specifically with what organisations who receive requests from the police should be considering as part of the disclosure. So I just want to sort of pick up on a few interesting points following these developments. A question I'm often asked is how can we as a school make a judgment about what is relevant to the police's investigation? Because a school might, for example, it might not have all the background information, and you know, there could be circumstances that the police haven't shared and so on. And it is difficult. I would suggest as a starting point, you almost apply a common sense test. So if what the police has requested fails a common sense test, then go back for clarification. And if you do decide information shouldn't be shared for whatever reason, then in most but not all cases, I think it's important just to let the police know just in very broad terms of the sorts of information you hold that you are not minded to disclose, so that the police can make sort of better articulated representations if they feel it's relevant. Another question is should we tell people that we've received a police request for their personal data? And same principles apply whether it's the police have requested information about staff or about pupils or whoever it might be. The starting point absolutely is that you should be super careful before corresponding with the data subjects, because plainly there is a risk that you could tip them off about an investigation. If there's a pupil involved, obviously the pupil will be supported by children's services, and simply sort of contacting the pupil could sort of make things worse from their perspective. So be really cautious before sort of speaking to people. But equally, one of the things that jumps out for me from the ICO opinion is the importance of the ICO place. Excuse me, the importance the ICO place on data subjects being in control, and the just making sure that they understand what's happening, what data is being shared, and what the implications might be. Because quite often people don't realise the consequences for them. So if you have a pupil who's sort of happy for her, her entire medical history or academic records to be shared with the police, he or she may not realise that the other side, the defence, will crawl over that with a fine-tooth comb, and something as sort of anodyne as lying about smoking behind a bike shed 3 or 4 years ago could be used to attack their credibility. So it's just really important that we give proper consideration to all of these issues. And I would certainly suggest a dialogue with the police, just in terms of making sure that you're satisfied that the data subjects, particularly the victims, understand what's being shared and the implications of that. Okay. So we've also had some schools who have been asked to sign data sharing agreements, and so these are agreements with the police which sort of particularize how the sharing might take in practice, and the lawful bases and so on. I would just suggest that you should be cautious before signing up to one of these. I looked at one recently where the effect of the agreement was to place a contractual obligation on the school to share information as of when the police requested it, and that's clearly inappropriate, because that's just completely cuts across the school's discretion to decide what's right on a case-by-case basis. So they're not unlawful, but just be very careful before signing up to a data sharing agreement with the police. And then something that's overlooked is this, just my final point on the slide. We used to talk about requests for information from the police, but equally there are other public bodies with law enforcement powers who may make similar requests. And for example, a local authority wanted to know about school fees because they're investigating benefit fraud or whatever it might be. And so the same principles apply when you get requests from these other agencies. But as an additional step, I would just double check that if they say they're investigating a criminal matter, that they actually have the powers to do so. And because sometimes people will sort of quote the exemptions and gateways in the data protection legislation that are applicable to the police, when in fact what they're investigating isn't really a criminal matter. So just sort of be cautious and careful when you receive those requests. Okay, next slide, please. Okay, so the second thing I want to talk about relates to using photographs and videos, or images for short, in school context. And again, we've been having, as we always have, lots of questions about what schools should and shouldn't be doing here. There's a bit of the misconception which we see sometimes, which is this: sometimes schools will say to us, if somebody's face is obscured, or if, for example, it just shows the back of their head, that's not personal data, we don't need to worry about data protection. Well, that's not usually the case, because in the vast majority of cases, the individual will be identifiable. People will know who they are, even if their face wasn't sort of visible to camera. So just have that in mind. There's a distinction between using photographs for what I call operational purposes, for example, recording a drama lesson in order to provide feedback, or taking mugshots of pupils and staff for identification purposes, on the one hand, versus using images for publicity and marketing on the other. And where the real issues are, what we're really talking about here, is where the data is used for marketing purposes. So fundamentally, the school's obligation is to be transparent with people, so that they are very, very clear, and that they understand how their images might be used, what sort of events are they taken, where might they appear, and so on. We'll look at the transparency point in more detail in a moment, but just in terms of the bear traps we sometimes see, just make sure that that those staff who have responsibility for taking photographs, that they're all joined up with your safeguarding colleagues. So, because in any school, there'll be a small number of pupils who can't appear in images for very good reasons. So just make sure that no one is sort of included in a photograph if they appear on that list. We sometimes see something we sometimes see a situation where so everyone is aware of who can't be photographed, but then they might sort of appear in the distance in the background. So say if you're photographing a football match, and they might appear in the background. So just be really, really careful to make sure that people aren't inadvertently included if there is a safeguarding angle there. Okay, and then so photographs and videos is one of the areas where we see quite a lot of litigation. So if for those of you who've come to our talks before, you might have picked up that there's sort of the pendulum is swinging more in favor of the organizations in terms of data breaches. So it's now harder for individuals to bring data protection related claims. They're less likely to succeed. But one of the areas where there remains a real risk is around the use of photographs. And so just make sure, so if you publish a photograph in circumstances where a parent or people told you you shouldn't have done, then you're potentially looking at a data breach claim as well. Okay, next slide, please. Okay, so I mentioned the fundamental point here is that you've got to be really transparent with people about how their data is used in relation to photographs and videos. And so how would you approach this? Well, the approach that we've taken is to first distinguish between less privacy intrusive and more privacy intrusive images. And for those that fall in the less privacy intrusive category, I would suggest that you have an opt-out approach, i.e. you will take and use the image unless the pupil or parent tells you that you shouldn't. For those that are more privacy intrusive, I suggest an opt-in approach where you get people to sign a form, and you would only use and take the image if the person has actually signed the form. So you've got that evidence. So what do we mean by less privacy intrusive and more privacy intrusive use of images? So take a school prospectus as an example. I would definitely say that a class photo of a science lesson that sort of appears in the middle of the prospectus appears in the less privacy intrusive category. So for that sort of thing, there's no obligation to sort of get everyone to sign an images form, as long as you've been transparent so that people are told in the privacy notice, in your newsletters, and also told when the photograph has been taken as well. However, if you wanted to feature a pupil on the front cover, or maybe do a case study on them, then that would fall into the more privacy intrusive category, and I would suggest that you get someone to sign the opt-in form before doing that. So quite often it's pretty obvious whether something sort of falls into the less privacy intrusive or more privacy intrusive category, but there are all sorts of use of images that sort of fall into the middle category, where you could sort of argue it's sort of, on the one hand, it's not very privacy intrusive, but equally it is for these reasons. And so schools need to make a decision about sort of what sort of photos do they put in the opt-out and opt-in category. So a good example is photos that appear on social media. So some schools will only do that if they've got a signed images form from the parent or the pupil, but some simply rely on opt-out wording and leave it up to the individual to let the school know if that's a concern. So it requires judgment. Okay, so where does consent fit into all of this? We would advise against getting consent for the use of images, but the opt-in approach that I've just described is very, very similar to consent. In fact, for all practical purposes, it's the same. The only difference is that rather than saying I consent on the form, it might say I don't object to. And the reason why we're suggesting schools give consent a wide berth here is because the ICO have recently produced some guidance, and now the guidance was aimed at academic research, so it's not really aimed at schools or charities as such. But one of the perhaps unintended consequences of the guidance is that if you get consent for something, it's more difficult to include that thing in your archive. So you could end up with sort of the ridiculous situation where you can't include a copy of your school prospectus in the school archive because some of the photographs were obtained on the back of consent. But to reiterate though, even if legally there's a distinction in all practical for all practical purposes, consent and opt-in are the same. It's just about sort of having that evidence that the individual didn't object to the photographs and videos. Just to finish off this section then, one of the questions we are asked is so who do we need to speak to? Who do we need to sign the form? Is it the pupil, the parent, or both? And as Claire mentioned, children are generally seen as being mature enough from the age of 12. And so our approach is to suggest that for those in year 6 and below, you should be corresponding with the parent. For those in year 7 to 11, you should be dealing with both the parent and the pupil. But when the pupil reaches 6th form, it's fine just to deal with the pupil without involving the parent. Okay, So that's everything I wanted to cover off on images. Could we have the next slide, please, Emma? Okay. So I also just wanted to mention data protection and information security e-learning for schools. So this is our online training for school staff on data protection compliance, and it's all staff training. Excuse me. So it's aimed at those who don't have a data protection specific role. It's to help you sort of be able to sort of demonstrate that you're complying, that you've provided appropriate training, and it's specifically written with schools in mind, with school-specific examples and so on. So do let us know if you would like further information. We're also doing a online training for data protection leads. So that'll be quite different to the all staff training, but that's sort of still in development. So we'll update you on that on due course. Okay, so we managed to successfully finish in good time before the end of the hour. So it's over to everyone else if you want to ask. So I see we've already got a few questions. So Claire, do you want to start off with some of the access request questions, and then I'll pick up the other ones. Thank you.
Absolutely. Thank you everyone for your great questions. So I'm not sure whether you can see the questions that I can see, so I'll read them out just in case. So the first question relates to having an out of office. So when I was speaking a moment ago, I mentioned that there's no exemption. The clock doesn't stop during the school holidays for access requests. In the state sector, freedom of information, the rules are different, but for subject access requests for all the organisations, there's no kind of extension of time essentially for where it's school holidays or bank holidays or even weekends. So regarding this out of office point that I mentioned, so my advice is that all staff members should have an out of office on if they're not going to be picking up emails, just in case you do receive a SAR. The law is grey on this and the ICO guidance doesn't cover this either, but I think if someone makes subject access requests to a staff member during the school holidays and receives that staff member's out of office, which says, I will not be checking emails until the 3rd of September. If you require a response before then, please contact X. I think that's perfectly reasonable. And that if the person doesn't then contact X as they were clearly instructed to do by the out of office, I think there is a reasonable argument to say that you didn't actually receive that request until the staff member saw it. Now, I should say that the law is silent on this, and I can't find any ICO guidance on it either. So really, it's a reasonable situation. It's never actually cropped up in practice that I can think of. I do know of a number, I've said number, 1 or 2 schools have been caught out by receiving a subject request in the post, and the post wasn't then properly passed on. So make sure you've got measures in place there. But regarding emails, I think most people who receive an out of office do then contact the person on the out of office. So hopefully that won't be too much of an issue. The second question is, if the data subject's name is in an email as they are an addressee of the email, so I assume that means a recipient of the email, are you required to disclose the email even if fully redacted content? So basically, are you required just to disclose the fact that they were an addressee to the email, but none of the content is their personal data, so that's not disclosable? Personal data would be limited to the email address, but still personal data. So would failure to provide that data be a breach? So that's the question. So you might remember I mentioned that the entitlement under a subject access request is to a copy of the person's personal data, but not to a copy of the document, email, piece of information, however we put it, that contains that personal data. So the entitlement is to the personal data alone, which means that you can extract rather than redacting. That also means that the person is only entitled to a copy of their personal data once. So if the person's personal data as it is here is their email address, well, as long as you are disclosing their email address somewhere else in the disclosure, I think you're covered, because you're disclosing the fact that as a school, you hold that person's email address and you're giving that to them. You're showing that you hold it. Couple of other points on that though. You might be aware that people are also entitled to supplementary information about their personal data. And this includes categories of recipients and also any available information as to the source of that data. So if there is extra information there that you need to provide in terms of source, think about how you'll provide that. But if we're talking about a staff member, for example, you wouldn't need to provide a redacted copy of every single email they'd ever received that didn't contain their personal data. So their entitlement is to a copy of their personal data, and you only need to give them that once. But remember that they are also entitled to information about source and recipients too. The next question relates to something that we actually see quite a lot, which is a subject access request received in the context of parents going through an acrimonious separation. And what tends to happen is that either one of them or both of them make a subject access request to the school seeking a copy of their own personal data, which they're entitled to, and also making a request for their child's data as well. And what we assume that they are really looking for here is information about the other parent that they will probably try and use in court against the other parent during a custody battle, that kind of thing. So this question is very specific to the facts of this particular case. So I'd be happy to speak to the person who made this request, asked this question offline, if that would be helpful. But broadly speaking, it looks as though the school has refused to give them each, because both parents here have made the subject access request, made a subject access request, and the school have refused to give them, I'm just reading now, each other's email address emails regarding their son, although complied with the rest of the SAR. And it looks like the mother isn't happy with the fact that she hasn't been given everything. So again, I can't really speak to the specifics of this case without knowing a bit more detail and seeing the documents that have been withheld, obviously, to tell you if you've done it properly or not. But the key exemption that you're going to be relying on here is something called the mixed personal data exemption. And this basically means that if you can't give the requester, let's say mother here, her personal data or her son's personal data, assuming her son is either under the age of 12 or you've got his authority, without also revealing information about father, and that includes that father is the source of the data, that then constitutes mixed personal data. So you can't give mother her data without revealing information about father. You just can't separate the two, that intertwined. Where it comes to mixed personal data, that data is only disclosable either with the other individual's consent, but there's no obligation on you to seek consent, and often it's not appropriate to do so, or if it's reasonable to give that data, even though you'd be revealing information about somebody else. Now, in a situation like this, where it's acrimonious, I would imagine it wouldn't be reasonable in the vast majority of situations to give that data. But as I said, we shouldn't be applying exemptions in a blanket-like fashion. You do, strictly speaking, need to go through and identify for each piece of personal data and apply that balancing test, essentially, the reasonableness test, which is essentially mother's right to her data versus father's right to privacy, and balancing those up. So, but generally speaking, in terms of the ICO, and it looks like you've spoken to the ICO on this one, ICO are a very pragmatic regulator when it comes to subject access requests. They're already also very under-resourced, so they do not have the time as a regulator for every complaint they receive about subject access requests to kind of fully investigate it, ask you for copies of documents, that kind of thing. I actually haven't known the ICO really properly look into a SAR since the GDPR came in, when the number of SARs made just exponentially went up quite a lot. They just don't have the resources to do that. So often what the ICO will do is they will put the onus back on you as a school to resolve the issues with the complainant yourself, essentially. Now, that doesn't mean that you have to completely bend over backwards and give them everything they want. You should stand firm if you think that what you've done is correct. But there is a certain amount of an obligation on you to kind of explain to the individual what the law is, essentially, and explain to them why you think what you've done is correct. But it sounds like a bit of a hard one, so I'd be more than happy to discuss that offline if that would be helpful. Andrew, I think the next one is for you, which relates to kind of other authorities requesting personal data.
Yeah, thank you, Claire. So question is, on the point about other authorities requesting personal data, are there any risks in sharing information with the SRA, the Solicitors Regulation Authority, if they have asked for a written statement as part of their investigations into a case? To be honest, I would need to know more about the circumstances of the request to give a proper view. So it may be, for example, that there are court proceedings going on, in which case there'd be different considerations. But in terms of broad principles, as I said, the principles that we talked about relating to the police can have wider application with other authorities. The next question, should consent be updated when children reach the age of 12 or lower 6? First, just to reiterate, if we're talking about images, it's not consent, it's opt-in. So to all intents and purposes, it looks like consent, but it's just not called consent. But to answer the question, yes, absolutely. I would, once the pupil is in year 7, then yes, get them to sign the opt-in form. And I think it's important as well. So just every year, just make sure that you've drawn pupils and parents' attention to your practices. For example, in the privacy notice, in the relevant school newsletters. And also if there's an event where photographs are going to be taken, then just remind people what's going to happen so that they are fully aware and they have an opportunity to raise concerns. So I'm just looking to see if there are any more for me. So this is an interesting one. Is there an overall guidance regarding the disposal of school email accounts of students leaving the school? Can the school include this in its disposal policy, that where a student leaves the school, e.g. after 3 months, the email account of the leaving student will be disposed of, deleted? Is there similar guidance for staff, trustees and volunteers? That's a really interesting question, actually. We would always suggest schools should be super cautious before deleting emails. The appropriate retention period depends on what the email contains rather than the fact that it's an email. And so what should happen in practice is that particularly when we're talking about staff, trustees and volunteers, is that the school makes sure that the email gets filed in the right place so that the appropriate retention period attaches to it. But we all know in practice that doesn't always happen. I did a survey recently where I asked a number of schools how long they keep emails for, and there was a complete breadth, everything from we delete them after 6 months to we keep them indefinitely. But as I said, the important thing is to make sure that anything that's important that you need to keep finds its way to the relevant location so that it's kept in line with your retention practices. Okay, I'm going to hand back to Claire because we've got loads of questions on subject access requests.
And surprisingly, lots on subject access requests. So I'm just scrolling up a bit. Okay, so question, this is a good one. So can the school appoint one person to receive the SAR rather than all staff and trustees potentially receiving one? And if they do, can they pass it on to the bursar? And then this person says that this is what they have in their data protection policy now. Any individual wishing to access their personal data should put their request in writing to the bursar. So you cannot require people to make it to a particular individual. You can by all means encourage them, and you can even say, look, for your request to be dealt with as promptly as possible, we suggest you make it to the bursar, the data protection lead, but you cannot require it. So it's still a valid subject access request if it's made to anybody at the school, any staff member or governor at the school. Yes, so that's the importance of staff training here, that anyone that is kind of public facing, as it were, anyone that has contact with parents, for example, should know how to recognize the SAR for that very reason. And it's really important that they immediately pass it to whoever the data protection lead is, for the data protection lead to then respond to it. So it's not the staff member's responsibility to respond to it, it's their responsibility to recognize it and then pass it to the appropriate person who will then respond to it. And then next question, we've got, if we get a SAR from a parent about the personal data of an existing student and the student is over 12 years old, can we check with the student if he or she is okay for us to provide this information before sending the data to the parent? Not only is it okay for you to do that, you should be doing that. So as I said, the right to make a subject access request belongs to the child. It actually always belongs to the child. It's just that once they reach a certain level of understanding and maturity, they are then able to exercise that right. And as I said, as a general starting point, the ICO say that 12 years old is reasonable. It's not a black and white situation. If a child has learning difficulties, for example, it might be high, it might be older than the age of 12, but 12 is a good starting point. So the thing to ask yourself is this child, and you will know this better than me, you know, this teachers at the school will know this better than us, you know, is this child able to understand what a subject access request is? And it's not that hard a concept to, you know, get your head around. So you would think age of 12 is probably appropriate. So at that point, the parent needs to evidence to you, the school, that their child genuinely authorizes them to make the request on their behalf. And that evidence can be by all sorts of different ways, but you need to satisfy yourself that the child genuinely understands what they're authorizing. So if it's a current student, like I think in the example here, have a chat with them. You know, you've got contact with the student, you know, have a telephone conversation with them if it's school holidays, but, you know, sit down with them, say, look, your parents made this request. Are you comfortable with us responding to them? There is nothing to stop you actually responding directly to the child rather than to the parent. And then the child can decide what they want to share with their parent if they want to, because it is the child's right. It's not the parent's right. Same also applies if it's a solicitor making a request. If you don't think that the individual fully understands the scope of the information that might be disclosed, nothing to stop you actually sending it to the individual, who can then decide to share it with their lawyer if they want to. So as I said, just because it's the lawyer making the request gives it no greater authority. I'm conscious of time, so I think I've just rattled through another subject access request one if I can find one. So further to this question is further to your comments on subject access requests. If I'm sending a data check form home, can I include contact details, personal data for two parents separated or not? So that's not really a subject access request question. That's more a data sharing question. If parents are separated and you don't think that they will have necessarily each other's contact details, so if it's a really acrimonious separation, father, for example, might not want mother to have his mobile number for whatever reason, then you shouldn't be sharing that with the other parent. So do think about what it's going to vary on a case-by-case basis. But I would be quite wary of sharing contact details of one parent with a separated partner if, for example, there have been allegations, particularly if there have been allegations of things like domestic violence, that kind of thing, which we do see from time to time. So do be a little bit careful there. I think it's a judgment call, to be honest, but yeah, do be a little bit careful about sharing that type of data with two people where they are separated and no longer together. You would hope they've got each other's contact details for the reason that they're, you know, raising a child together, but you never know what safeguarding issues there might be lurking in the background there.